What happens when the people running our companies, the individuals we trust with, well, our investments, our jobs, what happens when they fail? Or maybe even worse, what if they abuse that huge amount of power they have? It's a question that really hits home for economic trust. So today we're doing a deep dive into the legal tools designed to stop those kinds of abuses. We're going to unpack the Company Directors Disqualification Act 1986. You'll hear us call it the CDDA. Our mission really is to get under the hood of this law. How does it try to keep unsuitable people away from director roles? What sort of behavior actually triggers disqualification? And importantly for you, what are the real-world effects? Now, this act, it actually came about partly because of a really specific, nasty problem back then, these so-called Phoenix companies. Imagine this. A director runs a company into the ground, loads of debt, creditors left with nothing. Then, poof, almost overnight, the same director starts a new, very similar business, totally free from the old company's debts. It was seen as, well, frankly, reprehensible, a complete abuse of limited liability.
Absolutely. And that Phoenix issue was definitely a major trigger, no doubt about it. But the CDDA, its scope, its ambition, it actually goes quite a bit further. It's really trying to set a wider standard for, let's say, commercial integrity. Think of it as a safety net, trying to protect everyone, creditors, employees, the public, from a whole range of bad behavior. Not just Phoenix teams, but, serious negligence too.
Okay, so that's the why. We've got the Phoenix problem as a starting point. But let's dig into the whats. What other kinds of conduct was this act really designed to tackle?
Right. So the CDDA basically lays out three main categories of conduct that can get a director disqualified. And it's important to note, sometimes the court has to disqualify someone if the conditions are met. Other times it has some leeway, some discretion. Okay,
three categories. Let's start with the first one. You mentioned this idea of general misconduct. What kind of actions are we talking about here?
So under this general misconduct umbrella, there are three main things. First, getting convicted for a serious crime, what the law calls an indictable offense. This has to be related to the company itself, its promotion, formation, management, liquidation, or even just handling its property. We're talking serious stuff here.
And the consequences?
They can be pretty severe. Disqualification for up to 15 years from a higher court, or even up to 5 years from a lower court. That's a long time out of the game.
Okay, serious crime is one. What's the second?
The second is about persistent breaches of companies' legislation. And this is interesting because it's not necessarily about massive fraud. It's more about repeatedly failing to do the basics filing documents with the registrar, like accounts or annual returns, giving the required notices.
So just not keeping up with the paperwork.
Essentially, yes, but persistently. The act is quite specific. If you've got 3 or more defaults on record within a 5-year period, that's considered conclusive proof. It shows the law isn't just focused on the big scandals, but also on directors taking their basic administrative duties seriously. The maximum disqualification here is 5 years.
Right, so consistent neglect has consequences. And the third point, under general misconduct.
That's fraud specifically linked to the winding up of a company. This covers knowingly carrying on business to defraud creditors or for any other fraudulent purpose when the company is going under. It also catches any other fraud or breach of duty by the people involved in the winding up process, like the director or the liquidator. And for this, because it involves intent to defraud during a vulnerable time for creditors, the maximum is again up to 15 years.
Okay, so it's a real mix then. Major crimes, yes, but also consistent failure on the admin side, and specific fraud when a company is collapsing. It shows being a director comes with, well, a lot of rules you need to follow. Now, this second category, disqualification for unfitness. This feels like it gets right to the core of keeping potentially harmful people out of these roles. This is where it gets really interesting, I think, for you listening. How does the law define unfitness? It sounds a bit vague.
It does sound potentially vague, but this is really central to the act, and the courts have done a lot of work fleshing it out. There are 2 main triggers here. First, and this is key, directors of companies that have gone insolvent. If a director of an insolvent company is found by the court to be unfit, the court doesn't just have the option, it has a duty to disqualify them.
A duty. So no wiggle room there if unfitness is proven.
Exactly. The disqualification period must be at least 2 years and can go up to 15 years. The second trigger is following an investigation into a company's affairs. If official inspectors investigate a company and their report concludes it's in the public interest to disqualify a director because of their conduct, the Secretary of State can apply for an order. Again, up to 15 years is possible.
Okay, but what is unfitness? You said it's not just crime.
Precisely. And this is where case law is vital. A really important case, Re Low-Line Electric Motors from 1988, made it clear that, and I quote roughly here, ordinary commercial misjudgment is in itself not sufficient. So just making a bad business decision, even one that leads to failure, isn't enough on its own. It needs something more.
Like what? What's the something more?
The court in Low-Line said it requires a lack of commercial probity, or in really extreme situations, gross negligence or total incompetence.
Commercial probity. Can you break that down for us?
Sure. It basically means honesty, integrity, acting in good faith in your business dealings. It's about fundamental business ethics. And another case, Reese Stanford Services, sort of built on this. It said the public needs protecting not just from obvious dishonesty, but also from directors who simply fail to appreciate or follow the duties that come with having limited liability protection.
So it's about understanding the responsibility that comes with the privilege.
Exactly. And then Reese Seven Oaks Stationers in 1990 took it even further. It established that you don't necessarily need to prove dishonesty for someone to be found unfit. The court said, incompetence or negligence in a very marked degree can be enough. It doesn't have to be total incompetence, but it has to be significant.
Wow. So serious incompetence, even without bad intentions, could potentially be enough. That really raises the bar, doesn't it?
Yeah.
Where do courts draw that line between a bad call and marked incompetence?
It's definitely a fine line, and it often comes down to patterns of behavior. Are we seeing repeated failures? Things like not keeping proper accounting records at all, letting the company trade recklessly when it's obviously insolvent, maybe diverting company funds inappropriately, even if not outright stealing. It's about conduct that shows a fundamental disregard for the director's duties, suggesting that person just isn't fit to have the protection of limited liability going forward.
Okay, that makes sense. So unfitness isn't just about deliberate cheating. It can be about a really serious, ongoing failure to meet the basic standards expected of a director. That's a critical point for you, our listener, to understand. It broadens accountability quite a bit. Now, besides those main categories, general misconduct and unfitness, are there any other sort of specific situations that automatically mean disqualification?
Yes, there are a few others the Act covers specifically. For instance, participating in what's called fraudulent or wrongful trading under the Insolvency Act. That's basically continuing to rack up debts when you know the company can't possibly pay them back. That can lead to disqualification under Section 10 of the CDDA. Also, if you're an undischarged bankrupt, you generally can't act as a director. That's Section 11. It's pretty automatic. And there's Section 12, which relates to failing to pay under a county court administration order. These are more specific triggers, often linked to previous financial mismanagement or insolvency issues.
Right, makes sense. So let's say a court does decide to disqualify someone. What does it actually stop them from doing? Is it just being called a director?
No, it's much broader than just the title. Section 1 of the Act is very clear. A disqualified person cannot, without getting specific permission from the court, be a director of any company. But it also stops them from being a liquidator or an administrator of a company or a receiver of company property. And crucially, it stops them from being involved in any way directly or indirectly in the promotion, formation, or management of a company.
Anyway, so you couldn't just be a consultant who's really pulling the strings.
That's exactly what it's designed to prevent. You can't just act as a shadow director or operate through someone else. The ban is meant to be comprehensive.
But you mentioned without specific permission. That's interesting. So it's not always a 100% absolute ban. Can people get exceptions or leave, as you called it? Doesn't that kind of defeat the purpose?
That's a really good question. And yes, the courts can grant leave, but it's not common, and it's usually under very strict conditions. It's about balancing the need to protect the public with, perhaps, the individual's ability to earn a living in a limited capacity, or maybe allowing them to wind down affairs properly. There have been cases, for example, re-Ipcon fashions, where leave was granted just for a short time so the director could sort out their business affairs in an orderly way. In Low-Line, the same case we mentioned earlier regarding unfitness, leave was actually granted for the director to continue at one specific named company, but with conditions, I think, things like not being able to sign company checks or borrow money without a co-director's approval.
So director on probation.
Sort of, yeah.
Right.
With very clear guardrails. And in another case, a cargo agency, someone was allowed to work in management at a company, but specifically not as a director. So they could use their skills, but not hold ultimate control or responsibility.
Okay, so there's some flexibility, but it sounds heavily controlled. What about how long these bans last? You mentioned up to 15 years, but is there a typical range?
Yes, the Re Sevenoaks Stationers case also provided guidance on the length. Lord Justice Dillon suggested dividing the potential 15-year maximum into 3 brackets to help guide courts. The top bracket, over 10 years, is reserved for the most serious cases. Think maybe where there's been large-scale fraud, or perhaps the director has been disqualified before. Then there's a middle bracket from 6 to 10 years for conduct that's serious, but doesn't quite hit that top level of gravity. And the lowest bracket is 2 to 5 years for cases considered relatively not very serious. Remember, 2 years is the minimum for unfitness relating to an insolvent company. The structure aims for some consistency.
Right, a tiered system based on how bad the conduct was.
Yeah.
Makes sense. Now, what if someone just ignores the ban? What happens if they defy a disqualification order and try to act as a director anyway? What are the actual teeth in this act?
The act takes breaching an order very seriously. The penalties are quite stiff. If someone acts as a director or in any of the prohibited roles while disqualified, they can face criminal prosecution. On indictment, meaning for the more serious breaches dealt with in a higher court, it could mean up to 2 years in prison and/or a hefty fine. Summarily, in a lower court, it's up to 6 months and/or a fine.
So actual jail time is possible.
Definitely. And there's more. If a company allows a disqualified person to act in a prohibited role, the company itself can be guilty of an offense. And any other director or manager who consented or sort of turned a blind eye could also be prosecuted.
Okay, so it spreads the responsibility.
Yes, and perhaps the biggest deterrent for the individual is personal liability. Section 15 makes a disqualified person who acts in breach of the order personally responsible for all the relevant debts of the company incurred during the time they were acting illicitly.
Wow, so the limited liability protection completely disappears for them.
Completely. They could lose their house, their savings, everything to cover the company's debts from that period. That's a massive financial risk. And finally, for transparency, Section 18 requires the Secretary of State to keep a public register of all disqualification orders. Anyone can search it, so it's hard to hide a disqualification.
That personal liability and the public register, those sound like really powerful tools. Okay, let's try and bring this all together with a real-world example. You mentioned the courts walk a fine line. Can you tell us about that Re Uno case from 2004? How did it play out?
Yes, the Re Uno case, or Secretary of State for Trade and Industry v. Gill, is a really instructive one. It involved 2 furniture companies that were in pretty dire financial straits, deep trouble. But the directors were trying to find solutions, seeking investment, trying to keep trading to find a way out. One of the companies, Uno, continued taking deposits from customers for furniture orders.
And the furniture was never delivered.
Exactly. The company eventually went into liquidation, and those customers lost their deposits. Now, here's the crucial part. The directors had apparently been advised they could have put the deposit money into a separate trust account to protect it.
But they didn't.
They didn't. Their defense was that they needed that cash flow, that deposit money, just to keep the business alive day to day while they were desperately trying to secure a rescue package or sell the business. They argued they were acting in what they thought was the best chance of saving the company overall, even though it risked the deposits.
So the Secretary of State applied to disqualify them for being unfit, presumably arguing they shouldn't have risked customer money like that.
Precisely. The argument was that continuing to take deposits you couldn't guarantee fulfilling, especially when advised about trust accounts, amounted to unfit conduct. But interestingly, the application to disqualify them was unsuccessful. The court didn't disqualify them.
Really? Why not? It sounds like customers lost out quite badly.
They did, and the court acknowledged that. But the judgment emphasized that disqualification isn't automatic just because a company fails and people lose money. It requires conduct that is genuinely dishonest or shows that lack of commercial probity we talked about, or is grossly negligent, making the person unfit. In this specific case, the court decided the directors had been pursuing what seemed like realistic chances to save the businesses right up until the end. Their actions, while ultimately unsuccessful and unfortunate for the customers, weren't seen as dishonest or demonstrating a lack of probity in the circumstances. They were seen as trying, perhaps desperately, to rescue the situation rather than deliberately trading improperly. So the court found them essentially blameless in terms of unfitness for disqualification purposes.
Wow. That case really does highlight that fine line, doesn't it? Between making difficult, maybe even flawed commercial judgments under immense pressure and conduct that crosses the line into being legally unfit. It shows how much the context and the perceived intent really matters. So wrapping this up, our deep dive into the CDDA 1986 has really shown, I think, how the law tries to perform this tricky balancing act. On one hand, protecting the public, creditors, everyone from corporate abuse. On the other, recognizing that business involves risk and failure doesn't automatically equal misconduct. We've seen that unfitness is broader than just fraud. It can pull in serious incompetence or persistent failure to follow the basic rules.
Exactly. And if you link it back to the bigger picture, it really underlines the significant responsibilities that come with limited liability. It's a privilege, not a right, and the CDDA acts as a critical guardrail. It aims to ensure there's a minimum standard of ethical behavior and competence at the top of companies, which is vital for confidence in the whole economic system.
And that leaves us, and you, our listener, with a really interesting question, I think. In today's world, businesses are always under pressure. Things can go wrong quickly. How do we tell the difference? When is a business failure just that an unfortunate failure in a tough market? And when is it down to conduct that really should trigger legal intervention like disqualification?
It's definitely something to mull over.